Salam Satu Malaysia. Breaking news. There's a case going on in the High Court of Malaysia regarding medical negligence. Let's go in and watch. My lord, with that, I end my submission. So this is the plaintiff, Sin Ying, and this is her lawyer, Miss Ying Chia.
Thank you, plaintiff. Defendant, you have anything to say?
And this is our judge, Lord Sefena. And this is the defendant, Jia Xuan. And this is her lawyer, Yap Zhi Chen. Defendant Sin Ying has decided to sue her daughter, Jia Xuan, due to her loss of range of motion after the surgery carried out by the doctor after breaking her arm in an accident. She sought for treatment from the doctor, which then carried out open reduction and internal fixation, which is a type of surgery used to stabilize and heal broken bone. Doctor did not inform that 0.5% probability of people who undergo this procedure might experience side effects. High Court Judge Lord Sefena held that the doctor was not guilty because the doctor had acted in accordance with the practice accepted as proper by a responsible body of medical man skill in a particular art. You are watching Careless News. Thank you. So we are here to discuss, do UK and Malaysia still use Bolam Test as a reference for medical negligence cases? First and foremost, what is negligence? Negligence is the most important tort in modern law. According to law definitions, negligence means a failure to take reasonable care to avoid causing injury to others that a reasonable prudent person would have exercised in a similar situations. It allows a claim where a defendant had breached a legal duty to take care, and as a result of that breach, damage or injury has been caused to the claimant. Tort of negligence have three main elements. The first one is the defendant must owe the claimant a duty of care, the defendant must breach that duty of care, and the failure must cause damage to the claimant. A duty of care is a legal responsibility of a person or organization to avoid any behaviors or omissions that could reasonably be foreseen to cause harm to others. When there's a breach of duty of care, is where defendant has fallen below the standard of behavior expected of someone undertaking the activity concerned. Next, we'll talk about medical negligence. Medical negligence is defined as the negligence, improper, or unskilled treatment of a patient by a healthcare professional. This can include negligence care from a nurse, physicians, surgeon, pharmacist, dentist, or other healthcare workers. In layman term, medical negligence is often used as medical malpractice. Strictly speaking though, medical negligence is the only one required legal element of a medical malpractice claim. It is an act or omission by a medical professional that deviates from the accepted medical standard of care. Proving medical negligence is similar to most other forms of negligence. Generally, the plaintiff needs to prove three elements. The medical personnel owed them a duty of care, the duty of care was breached, and the breach was the cause of the person's injury. Many of the cases involving special skill concern medical negligence. In medical negligence case, the defendant should be compared with a reasonable person of the same specialist and status.
Hello, my name is Sefena Eunice, and in this part of the video, I'll be talking about the history that led to the development of Bolam Test and also the facts in this case. Firstly, it's important to note that holding a medical professional responsible for injuries or death was initiated in the Code of Hammurabi, which uses the concept of delicts. Eventually, this law was expanded to apply to free men in addition to slaves, says O'Connell and Carpenter in the year of 1983. In the 1200s, Roman law spread through Europe. Laws created concerning medical negligence was based on Roman law, and it's still developing to this day. The neighbour principle in the landmark case of Donahue versus Stephenson, 1932, to establish when a duty of care might arise. Lord Wilberforce suggested two-stage tests in the case of Anne versus Merton in the year of 1978, and it established that it requires, first, a proximity relationship based upon forcibility, and secondly, consideration of reason, or in other words, policy reasons why there should not be a duty of care. This changed the way in which the neighbour test was applied, where courts used it to establish and expand of new areas in this tort. After Anne's case was overruled by the case of Murphy versus Brentwood in District Council, followed by the 1966 practice statements, courts set up three-stage tests, which is used in the case of Caparo versus Dickman. There were three tests in this case. Firstly, whether the duty cause is reasonably foreseeable. Secondly, was there a relationship of proximity between defendant and claimant? And thirdly, is it just and reasonable to impose such a duty? Caparo's test is now applied when a factual situation is presented in court to decide whether a duty of care exists or not. However, over time, court developed more detailed and restrictive rules that applies in cases where there's damage. However, in Bolam's case, 1957, medical negligence was established. Let's see the fact of this case. Bolam versus Friern Hospital Management in 1954. John Bolam was admitted to Friern Hospital because relapse of depression. In accordance with the hospital's usual practice of not administrating a relaxant drug or applying manual restraint, the psychiatrist, Dr. Alfred, gave him electroconvulsive therapy, or in short, ECT. Nurses were present on either side to prevent him from falling out of the couch. But Bolam suffered a acetabular fracture of both hips. So, later on, the operation were completed. So, Mr. Bolam sues doctor for firstly, failures to use relaxant drug without restraining the compulsive movement of Mr. Bolam's manually. Secondly, he sued for failing to warn Mr. Bolam for the risk. He also sued hospital for negligence in permitting Dr. Alfred to administer the treatment without relaxant drug, and also for vicarious liability. High Court Judge McClare Justice directed the jury. A doctor is not guilty of negligence if he has acted in accordance with the practice accepted as proper by a responsible body of medical men skilled in a particular art. Putting in the way around, a doctor is not negligent if he is acting in accordance to such a practice merely because there's a body of opinion that takes a contrary view.
Hi, I'm Jia Xuan. Now I will talk about the contrast between the standard of care of an ordinary skilled person and the standard of care of a doctor. For the determining the standard of care of an ordinary person, the reasonable man test is used. The reasonable man test is an objective test in personal injury cases that the court used to determine if a defendant acted like other person would have in the same situation. However, for the standard of care of doctor, the reasonable man test is not to be applied. On the contrary, as mentioned before by Jing Yi earlier in this video, in medical negligence cases, the defendant should be compared with a reasonable person of the same specialism and status. Doctors have a different medical standard of care.
Hi, I'm Ying Chia. I'll be continuing on the medical standard of care. The medical standard of care is typically defined as the level and type of care that a reasonably competent and skilled healthcare professional with a similar background and in the same medical community would have provided under the circumstances that led to the alleged malpractice. Generally, in a medical malpractice lawsuit, It is always a body of respectable medical opinion who will testify as to what the appropriate medical standard of care was under the circumstances and how the doctor's deviation from that standard played a role in the plaintiff's injuries. As illustrated in Bolam's case, a doctor is not guilty of negligence if he acted in accordance with a practice accepted by a responsible body of medical practitioners skilled in that particular area. Thank you.
Hi, I'm Eugene. I will be talking about the development and application of the Bolam Test in the UK in this video. Also, Jia Xuan will be talking about the departure from Bolam Test in the UK and the reason of the departure. In this video, we will be talking about the application and departure illustrated by several examples of cases regarding consent, examination, diagnosis, treatment, and clinic judgment. As we all know that Bolam Test is a landmark case in the area regarding medical negligence in UK. Doctors have a special standard of care in medical negligence. Bolam Test was applied in the area regarding consent. It is illustrated in the case of Cedarway and governors of the Bolam Royal and Marsden Hospital. The claimant suffered from pain in her neck, right shoulder, and arms. The neurosurgeon took her concern for a Sefena cord decompression, but did not include in his explanation the fact that in less than 1% of the cases, the same decompression caused paralysia. She developed paralysia after the spinal operation. The House of Law held that the defendant were not liable because the surgeon had followed the approved practice of neurosurgeon in not disclosing the risk of damage to the spinal cord and was not negligence. House of Law confirmed the application of Bolam and the plaintiff appeal failed. Law Schema held that English law must recognize the duty of a doctor to warn his patient of material risks inherent in the treatment he is proposing, in particular cases involving surgery. However, that in the medical aspect of advice by the doctor to the patient, the court and not medical judgment will determine if the doctor has breached the standard of care in medical law. Another supporting case is Chester and Afshar, that 2004. Miss Chester was referred to Dr. Afshar, a neurological expert, about some lower back pain. He told her that surgery was a solution, but the judge found at the first instance did not inform her of the 1 to 2% risk this operation going wrong. She suffered from a complication called cardiac ischemia syndrome. The High Court judge found that there was a causal connection between the failure to inform and Miss Chester's injuries. If she had been informed, she would have sought further advice and alternative. In the Court of Appeal, the judge upheld the conclusion of the High Court judge. The defendant appealed to the House of Law. The House of Law dismissed the appeal, holding that the defendant has failed in his tortious professional duty, satisfying the but-for test. One more supporting case is Montgomery and Leonard Sheikh held both 2015, which the Supreme Court held that Mrs. Montgomery had the right to be advised of the risk of shoulder dystocia. She also had the right to decide for herself what risk she was prepared to run relative to the delivery. In this case, Supreme Court replaced the Bolam Test for consent with a case where the materiality of risk involved had to be assessed by reference not to a responsible. Secondly, the Bolam Test is also used in the area regarding examination and diagnosis in setting the case Minor and West Midlands Regional Health Authority 1985. House of Law held that the consultants were not negligent as they had followed the practice that had been approved by a responsible body of medical opinion. Although there was a competent body to cite the decision of consultant was wrong, there was an equally competent body to support their approach. Thank you.
Hi, I'm Jia Xuan. I will continue on the application of Bolam's test in the UK discussed earlier by Regine. Later, I will be talking about the departure from Bolam's test in the UK. Considering area of treatment and clinical judgment, Bolam's test was applied in the case of White House against Jordan in 1981. House of Lords held that the defendant was found not negligent as the evidence did not establish that the doctor had departed from accepted practice. House of Lords restated that the Bolam test and rejected the argument that there was a difference between an error of judgment and negligence. Lord Denning confirmed that the Bolam test was still the appropriate test by which to measure standards of professional activity. However, there is a case that departed from Bolam's test, which is the case of Bolito against City and Hackney Health Authority. A child was brought to a hospital suffering from breathing abnormalities. The doctor summoned to deal with the matter never received the summons due to a low battery on her beat. The child died as a result. The child's mother sued for negligence, arguing that the child should have been seen and intubated. The House of Lords held that a defendant cannot escape liability by saying that damage would have occurred in any event, because he would have committed some other breach of duty thereafter. So, there was a need to decide if the hypothetical decision not to intubate the child would have been a breach of duty. The Bolam test said that an action cannot be a breach of duty if it conforms with a reasonable body of professional opinion. The professional opinion relied upon cannot be unreasonable or illogical. If the opinion were illogical, then the action would still be a breach of duty. Only in a rare case would the court find that the body of opinion is unreasonable. The recent English High Court decision in O'Hare and another against Coates and Company 2016 marks a shift from this long-established test imposed on a professional in medical negligence in the context of financial advice. In O'Hare, the claimants had suffered considerable losses following investment met with costs over a number of years, and claimed that Coates was negligent in advising them to make the investment on the basis that they were unsuitable and that as a result, a large proportion of their wealth was exposed to be a potential risk of loss. Interestingly, the court in this case moved away from the test for professional negligence, as set out in Bolam, and more closely followed the Supreme Court's approach in the 2015 case Montgomery against Lanarkshire Health Board.
Hi, I'm Ying Chia. Today, along with my friend Yap Zhi Chen, we'll be discussing on the development and application of Bolam's test in Malaysia, together with cases as illustrations. This will be the last part of this video. Before diving into our discussion of the application of Bolam's test in Malaysia, I would like to share a quote from an article of the well-known former Federal Court Judge, Datuk Sri Gopal Sri Ram. His article, titled "The Standard of Care, Is the Bolam Principle Still the Law?" Quoting from his article, it may come somewhat as a surprise to a layman in Malaysia that the standard according to which members of the medical profession in this country falls to be judged today rests upon principles laid down almost 2 centuries ago in Great Britain. Between the 1800s to 1957, there were a number of occasions on which the courts in the United Kingdom had to deal with the thorny questions as to what amounts to professional negligence in a doctor. It simply leaves us with the question, what is the judicial approach in medical negligence cases in Malaysia? Is it pro-Bolam, is it pro-Whittaker, or is it pro-Bolito? Now, back to the subject. The earliest case which applied the Bolam test was Swami against Matthews and another, a 1968 case. In this case, the plaintiff claimed the doctor owed a duty of care in diagnosis and treatment. The plaintiff went to see the first defendant, a doctor who was in the employment of the second defendant, for an itch on his hands and legs. He was given an injection of 5 cubic centimeters of acetyl arsen, which was alleged to have caused paralysis on the hands and his legs. The High Court dismissed the claim as the plaintiff failed to establish that the injection caused his paralysis. The case then went to the Federal Court. The Federal Court upheld the decision of the High Court on the same grounds that the paralysis was not caused by the injection and the first defendant was not negligent. Similarly, in the case of Ying Chia against Government of Malaysia and another, a 1967 case, they adopted the Bolam Test as well. The Bolam Test also applied in the area concerning a doctor's standard of care of disclosure and informing material risk to patients. In the case of Liu Sin Ying against Dr. Sharon D.M. Porraj, a 1996 case, the defendant was sued by plaintiff of negligence pertaining to an eye operation on his right eye, which was lost to post-operative infection. The issues were whether the defendant explained the material risk of infection to the plaintiff and whether the defendant acted in accordance with the body of a skilled man. The court applied the Bolam principle that in order to recover damages for failure to give warning, the plaintiff must show not only failure was negligent, but also if that he had been warned, he would not have consented to the treatment, which the plaintiff had failed to do so. Therefore, the defendant was not negligent.
Hi, I'm Jia Xuan. So now continuing on explaining the application and departure of Bolam Test in Malaysia. However, in disclosure and informing material risk to patients and providing medical advice, Whittaker test was also applied. Whittaker test originated from the case of Roger against Whittaker, which the issue raised was the plaintiff's allegation on the defendant's failure to advise her on the risk of sympathetic ophthalmia, although the risk was 1 to the 14,000, which resulted her to lose vision of her right eye. Now, the main issue here was, did the doctor's failure to advise and warn the risk inherent in the operation constitute a breach of duty? The principle derived from this case is in the medical aspect of advice by the doctor to the patient. It is for the court to determine if the doctor has breached the standard of care in medical law and not the medical judgment. An early case in Malaysia which adopted the Whittaker test was Kamalan Anak Perempuan Rahman and others against Eastern Plantation Agency 1996. Just an information, Whittaker test referred to as patient-centric, Bolam and Polito referred to as doctor-centric. Next, a landmark case which appealed from High Court to Court of Appeal and later to Federal Court of Malaysia, which departed from Bolam test, adopting the Whittaker test, was a federal court case called Phu Fiona against Dr. Su Fok Man and another in 2006. Prior to December 2006, the test for medical negligence accepted by the courts in Malaysia was generally known as the Bolam test or the Bolam principle. This test was applied to determine the doctor's standard of care in relation to the treatment and information given to the patient. The Federal Court on December 2006, in its judgment in the case of Phu Fiona against Dr. Su Fok Man and another, declared inter alia that the Bolam test, which has been the basis in determining the standard of care in medical negligence cases in Malaysia since her independence in 1957, is no longer applicable. The Federal Court held that the Bolam test has no relevance to the duty and the standard of care in a medical practitioner in providing advice to a patient on the inherent and material risk of the proposed treatment. The practitioner is duty bound by law to inform his patient who is capable of understanding and appreciating such information of the risk involved in any proposed treatment, so as to enable the patient to make an election of whether to proceed with the proposed treatment with knowledge of the risk involved or decline to be subjected to such treatment. The court further held that there is a need for members of the medical profession to stand up to the wrongdoings, if any, as in the case of profession and in other professions, In so doing, people involved in medical negligence cases would be able to obtain better professional advice, and that the court would be appraised with evidence that assists them in deliberation. On the basis of the Roger and Whittaker in 1992, would be a more appropriate and wearable test of this millennium than the Bolam test. Last but not least, for the standard of care in the area regarding value of expert medical opinion, court in Malaysia follows an approach which combines the Bolito and Whittaker test. In the case of Chai Hong Seong against Wong Min Hyun in 2010, the respondent brought a claim against the appellant dentist for negligence in respect of some dental work carried out on her right molar. At first instance, the claim was allowed. The appellant appealed to the High Court, raising several grounds of appeal.
To make a conclusion for the extent in which the Bolam test is applied in Malaysia, now let us get back to the question again. Which test prevails in Malaysia? The answer appears to be there is no test prevailing on its own. All the tests have its own strength and is relevant to be used subject to each fact of the case. It cannot be said that the Bolam test is no longer relevant, especially in Malaysia. There is still a need to have a certain standard for doctors in order to determine whether they fall short of that standards. Bolam test is still relevant for treatment and diagnosis, while the Whittaker's tests are more referred for the disclosure and informing material risk. Thank you.
So now, let's get back to the question, how far the Bolam test is still relevant in determining the standard of care of doctors in medical negligence cases in the UK and Malaysia today. In conclusion, for the UK, although the Bolam test still apply, courts are not obliged to find a doctor not liable for medical negligence purely because other medical experts have testified that his or her actions were correct. This was decided in the Bolito case, which was made into another landmark case in the area of medical negligence, where court can depart from the Bolam test. Therefore, it can be seen that Bolam test is still relevant to a certain extent as mentioned earlier in our points. On the other hand, for Malaysia, it cannot be said that Bolam is no longer relevant, especially in Malaysia. Bolam's test is still relevant for treatment and diagnosis. After the Fufiona's case in 2006, Whittaker's test would be a more appropriate and viable test in determining the standard of care of doctors in medical negligence of this millennium than the Bolam test.